Good evening, ladies and gentlemen. My name is Sengupta, and I'm the Research Director of Vidhi Center for Legal Policy. On behalf of everyone at Vidhi, a very happy Constitution Day. On 26th of November 1949, which is exactly 71 years ago to this day, the President of the Constituent Assembly, Babu Rajendra Prasad, in my view, gave an outstanding speech. In one part of the speech, he said these words, and I think this is quite apt, and it came back to me as I was thinking about what I'm going to say today, right at the beginning. And he said, and I quote, I am a man of the village, and although I have had to live in cities for a pretty long time on account of my work, my roots are still there. I therefore know the village people who will constitute the bulk of this vast electorate. In my opinion, our people possess intelligence and common sense. They also have a culture which the sophisticated people of today may not appreciate, but which is solid. Unquote. Today, this quote comes to mind because we are at a juncture where this divide broadly between ordinary folk and the sophisticated intelligentsia in relation to the health of the Supreme Court appears to be stark. In many conversations during my research with those outside the legal fraternity, I found a deep and abiding faith, particularly for the Supreme Court and the High Courts. Within the intelligentsia, particularly in the popular press, there, however, appears to be a deep dismay at what is transpiring in court. In this context, I felt it would be useful for us and important to have a discussion on judicial pressures and constitutional courage. This is not a discussion to say that someone is right and someone else is wrong, that the intelligence and common sense of village folk, in Rajendra Prasad's words, is superior to the intuition of the sophisticated. That's not the point at all. It's rather a discussion to understand in deeper detail what are the pressures of judgeship, how do governments view judges, and how can courts emerge from this crisis of confidence that it faces in certain quarters. To discuss these and more, I'm delighted to welcome today Justice B.N. Srikrishna, former judge of the Supreme Court of India, and someone who I think is the conscience not only of the judiciary but of the nation. Thank you very much, Justice Srikrishna, for joining us today.
Thank you.
We have Salman Khurshid, senior advocate, former law and foreign minister of the Union of India, who has a deep understanding of a judicial system and a dispassionate view of all that is right and wrong. Thanks very much, Salman, for joining us.
Thank you.
And we also have Dhruti Kapadia, an advocate on record in the Supreme Court and solicitor, who has very strong views on the subject and has seen this on ground every day because she encounters judges in her work every day. So I'm delighted that Dhruti can be here. Thanks very much, Dhruti, for joining us. And to the rest of our audience, thank you very much for joining in. We are delighted to be partnering with the Kautilya Society of the National Law University, Odisha, for this series of public conversations. The Kautilya Society is a student society dedicated to promotion of law and public policy. And NLU Odisha is one of the premier law schools in the country. It's also been nominated by the UGC for its nationwide celebrations of Constitution Day. And they have planned several events over the course of this year with a special emphasis on fundamental duties. In fact, they had a session today on taking fundamental duties seriously. I think that's a riff of Ronald Dawkins taking rights seriously with Justice Muhammad Rafiq, Chief Justice of the Orissa High Court. We are delighted to partner with NLU Orissa for this. This is a public conversation, so we encourage questions. Please do ask your questions in the chat box, and I'll try and take as many as possible through the course of this event. This is not meant to be an event with long speeches, but a question and answer session. So do keep those questions coming in. So let me start with you, Justice Sri Krishna. And since it's Constitution Day, I thought I'll start with something in the Constitution, the third schedule to the Constitution, which talks about oaths that are to be taken. Now, you have taken the oath of office. You took your oath of office first in the Bombay High Court, and then again, of course, in the Supreme Court. And you said, and I quote from the oath, that you will bear true faith and allegiance to the Constitution of India and perform my duty without fear or favor, affection or ill will. What do these words mean to you?
Thank you, Arghya. To correct you, I took this oath on 4 occasions. Once as the additional judge of the Bombay High Court, then as the permanent judge of the Bombay High Court, one as Chief Justice as Kerala High Court, and the last one as the judge of the Supreme Court.
So now you have these words fully by heart.
Ultimately, one must understand basically what is the job of a judge. The job of a judge is to do justice, as the Constitution itself tells you. justice not in the absolute sense of the good Lord himself, or in the sense of a monarch saying that whatever I say is justice, but within the parameters or bounds of the law. Now, there are two aspects to it. One is the judicial conscience, which acts within the bounds of the popular mandated law. The populace at a given time says that this is the law through its elected representatives, and the judge has to ensure that his justice fits in with this. But within that, he has a lot of elbow room to act. That is where the skill of the judge lies. In fact, I was just reading some time ago a beautiful saying that in Narada Smriti, there's a lovely saying. It says, Yatha shalyam vishakkayat uddharet yantrayuktitaha pradvivakas tatha shalyam uddharet vyavaharataha. It's a very nice saying. It says, just as a surgeon removes a foreign body, maybe a thorn or some sharp metallic object which has entered into your body, carefully by exercising of his yantra. Yantra is the implement, as well as yukti. Yukti is a skill or the learning that he has. He has knowledge of anatomy, he has knowledge of surgery, he has practice on cutting up corpses, etc. Similarly, Pradvivaka is the judge. The judge must remove the thorn of injustice by using the yantra, the right implement at the right time, the right procedure, and also the right principle behind it. Now, please note, this is a very apt illustration. Now, if I have a thorn on my foot, the surgeon will have a different implement, and the methodology he uses to remove it is quite different from removing a bullet from my stomach. Now, there is this doctrine of proportionality operating there also. If he is disproportionate, he is going to kill the patient. Similarly, you will absolutely do injustice. So the justice has to be proportionate to the injustice that you want to remove, but well within the parameters of the law. That should be your actual oath of office, and make sure that the Constitution has mandated it and the laws made in accordance with the Constitutions mandated it, and therefore I must operate within that bounds. That is what I understand by the office, oath of office.
So let's take an example as to where that analogy might come in. And this is an example that I must admit is the first time that I heard of you as a young boy in school was during the Sri Krishna Commission, which went in after the Bombay riots. And of course, a lot of our participants here are much younger. And the Sri Krishna Commission was set up to inquire, after the Bombay riots were over, to inquire into the incidents that had taken and to assign culpability. And Justice Sri Krishna became a household name then because he was a puny judge in the Bombay High Court, a fairly junior one, if I remember right, at that time, as in who was the only one who had the temerity to take it on at that point of time. So was that a particular occasion where you had to remember your oath of office, that there was considerable pressure, but you had to do your job as was assigned to you? How did you take that assignment?
Yes, you see, let me tell you, first of all, why did I accept this commission? Fools rush in where the wise men are fear to tread, where angels fear to tread. So there were a lot of angels in this Bombay High Court who feared to tread into this, and they flatly declined to accept this commission. I was number 3 from the bottom of 26 or 27 judges in Bombay. And I can resist a challenge. I said, okay, I don't know anything about it. I'm willing to try it and do it. But what really interested me was that I am a practicing Hindu. I'm not ashamed of admitting it. In fact, I boast about it. And come every Sunday, you'll probably notice me with a big tika on my forehead. In fact, I was popularly known as the tika wala lawyer in the bar room. So if anybody wanted to say, oh, the tika wala baitha hai. So when I was asked to do this commission, which was nothing but trying to draw a kind of conclusion from a right between Hindus and Muslims, I had this kind of a problem. So when the Chief Justice asked me, I said, I have no problem, I can do it. But then this is one difficulty. I wear my religion, if not on my sleeve, at least on my forehead every week. So do you think people will have some kind of satisfaction, some kind of confidence in me? The Chief Justice asked me a simple question, which really I took to heart. She said, Justice Sujata Manohar was Chief Justice at that time. She was a lady. So she said, that when you don your robes and sit in the court, do you consider yourself to be a Hindu or a Muslim? So without batting an eyelid, I said, I don't consider either. I consider myself to be a judge, simple and pure. Then she said, you have no problem, you should be able to do it. And that is how I managed to go ahead. And at any given time notice, I was required to be true to my oath of office, which is not treated as from the prism of a Hindu, not treated from the prism of a Muslim, but look at it objectively and say, hey, what? Of course, that was not a judicial decree or anything like that. But still, when ascertaining the facts and drawing your conclusions, you've got to be absolutely independent, devoid of these religious biases, religious coloring. And apart from that, I have, this is one small example that you showed me. I have had other occasions also. Now, for example, sitting in the Bombay High Court, I must have allowed the largest number of liquor permits petitions. So people were shocked. They said, why for a person who doesn't drink, why do you allow such people? I have allowed tobacco manufacturers petitions. Now, why did I allow them? Not because I love or hate tobacco, not because I love or hate liquor, but because the law requires me to decide in accordance with the law. And if the law was in favor of something, I must do it. Never mind what my personal inclination is.
That's right.
So that is the way I went about remembering my oath of office, whether it is commission or as a Judge of the Bombay High Court or Chief Justice in Kerala or in the Supreme Court.
So, Mr. Khurshid, I'll take that to you because Justice Sri Krishna has given us a textbook understanding of what a judge ought to be. And you've seen several judges in your time. And in your view, is this the typical judge that Justice Sri Krishna has painted the picture for us? Or is this something that you think is becoming rarer over time?
See, I have a difficulty here. And I must be plain and I must be honest. My difficulty is that judges are human. I think we all know that. And there are human frailties as well. To the extent that the training and the decision to be a judge factors into your life, you are a different kind of human being. You're not an ordinary human being. If an ordinary human being behaves in a manner which is judicious, in the language in my state, in UP, in Urdu, they say that he is munsif mijaz hai. That he has this gentle person has the mind of a judge. He has the manner of a judge, because that is the ultimate in a human being. I mean, short of God or godly person, a saintly person, I can't think of how high a human being can rise, except in the picture of a judge. But obviously, everybody can't do that. Everybody can't be Justice Sri Krishna. People will try, some will fail, some will fall short. Somebody may not even try, someone may be a little bit lazy, etc. So when they falter and they fail, the guns that get directed at them and the fire that one has seen of late, well-meaning maybe, but what you do is that your lesser God you are willing to destroy. The greater God is not always there. The lesser God you get at and you destroy. Does it help you? Does it help you? Now, some people say it helps because the next one will be more careful. My worry is that there may not be a next one. My worry is that your fire and that your attacks might destroy the institution so much that the lesser gods that live in that institution will bring the whole institution down. And it's like a parent being careful about how to discipline a child that you love. You must discipline. You must not spare the rod and spoil the child, as some people say, but you can't be like like the major in Sound of Music, where children are treated like regimented people, etc. Where do you find the right line? And I may be wrong, but I think that putting up with the frailties and failures of judges for the larger cause, but continuing to work on it in whichever method and manner is available. If a judge has just got a problem, you have a Chief Justice that you can talk to say, is there some way that you can counsel the judge? There may be other ways of reaching out through friends, through confidants, and so on. It's a very, very difficult moral problem. But I think the problem really is that we must not lose sight of the fact that there are icons. There are people who lay out the path, and we must find every persuasive way of pushing other judges along that path to say, that's really what you should be one day. That's what you should achieve, and that's what will get you gratitude and appreciation of people. And that is very, very valuable and very important for a judge.
No, I get that, and I think that's a very useful reality check.
Sorry.
Like every institution, as in there are obviously stars, and there are those as in who are good, but perhaps not stars. But perhaps and I'd like to push back a little bit on this, because the kind of solution that you were suggesting, as in perhaps the criticism of it might be that this is status quoist, right? We live in an age of transparency. We live in an age where if there are misdeeds, then people should know about the misdeeds, and where people should and where judges should be as accountable as those wielding state power. Now, the solution that you were, or not really a solution, but the thought that you were hinting at is that perhaps we should try persuasive means, as in, a nudge, nudge, wink, wink, to try and get judges to get back on track if they have digressed in some shape or form. Do you think in India today, given the fact that we do live in this age of transparency, of questioning, which may be excessive at times, but is good, overall, all things considered, do you think that this kind of solution, which is go to the Chief Justice to try and see what measures exist within the system, might have run their course? And maybe that's why it's out of that frustration that people are perhaps sort of being more candid than they would have been earlier.
It may be because we can't be absolutely certain, but I think it hasn't. I think that the art of conversation and the impact of conversation in our lives in India is underestimated. It's been relegated. It's been pushed back. I think we need to return to being able to talk without being suspected of having an agenda, of trying to hurt somebody, etc. Somebody will have to start this, and there is no better place than the judiciary. Judiciary is very tolerant. The way I see, and Justice Sri Krishna will step in. When you see a division bench say about a judge who is otherwise a good judge that he is in error. Of course, in an extreme case, that terrible word perverse is used. That this is a perverse way of looking at these facts. But to be in error, to tell anybody you are in error, and for that person to take it with good humor, is not easy for us. I mean, if someone came up to me and said, "I think you are in serious error," I would be taken aback. I would be a little bit hurt. It would certainly dent my ego. But the judges hear it every day from their colleagues, and it's only interesting that a judge who hears that you're in error on one day, a month later, could be sitting in the division bench, and the one who said you're in error could be sitting as a single judge. right? And then that whole story could go on. So I think judges by their training are able to tolerate criticism in a particular manner, not the kind of criticism what we see in the streets today. I mean, that's completely unacceptable.
But Justice Sri Krishna, just taking that to you, as in, I'm sure in many times you may have had your judges, maybe your judgments overturned either by a division bench or when you were in the High Court by the Supreme Court. Does it hurt? Do you take it personally?
I don't. And that's maybe a personal trait of mine, because I have known judges. In fact, when I was I remember when I was in the Bombay High Court as the judge who had been just appointed, I was sitting on a division bench with the judge who was the senior most at that time and later on became the Chief Justice of India. And the learned judge, some other judgment of a single judge came, who was much, much senior to me, but rendered as a single judge, which came in appeal. So I turned to the senior on the bench and said, do you think, he said, you write the judgment, the senior judge. So I said, should you think I should do it? He said, I know this chap is a little shirty, but I still want you to write the judgment because that is judicial propriety.
Okay, now I'll rephrase that question because every answer that you give makes you look even more superhuman than the previous one.
I'm just my experience. Now,
no, that's true.
It's not a lecture of a lecture, but I'm giving you exactly what happened in my life.
No, that's true. That's true. But I'd like to push you further on this. But when someone says that you are in error, and when courts, and that is of course on the judicial side, okay, you may feel intellectually upset. But now courts every day, whether rightly or wrongly, and maybe some criticisms that we are dealing with may be justified or unjustified, there could be two views on that. But if you go on to the social media and you see the kinds of criticism that exists about judgments, as it is vile, okay, it is absolutely vile. Now, are you seriously saying that this is like water off a duck's back, as if judges do not? I mean, I know judges should not, and I get that point. But do you think you know your brethren, particularly many judges in the Supreme Court now were your junior judges, both in Bombay High Court as well as in the Supreme Court, as you know that. Now, do you think that this is something that doesn't affect a human being?
There are two types of criticism. One criticism can be that this judge is intellectually poor, he is unable to think properly. One type of criticism. The other criticism is he's politically sold out. Third type of criticism, he is outright corrupt. Now, the first one is something that every judge can stomach, because after all, intellect depends on Salman is more intelligent, I am, you may be more intelligent, both of us to get together. Well, that's God given, I cannot help it. Maybe you have more experience, I have less experience. But corruption is something that is objectively seen, or at least perceived, if not seen. And then politically sold out is a perception that a person has. Now, I may say that according to me, the government of the day is right in this particular manner. Now, that may be jurisprudentially correct or jurisprudentially wrong. But half a dozen chaps will get up and say, he's politically sold out. Now, take for example, you're talking of the famous commission, Sri Krishna Commission. What was the final verdict that was rendered on the floor of the Maharashtra Assembly? The Chief Minister said, this is a Hindu Dveshi thing. So somebody asked him and said, have you read the report? He said, I don't have to read the report, but I know it's a Hindu Dveshi. Now, certainly it was outright stupid on his part, sorry, I'm using a strong word, to call me a Hindu Dveshi. Because I'm nothing but a Hindu. If you scratch me, you will find only Hindu. But the fact is, sitting as a judge, there was no other option. That was the material before.
That's right. So I think let's get to the heart of this current criticism. So Dhruti, I'll come to you. Now, a lot of the current criticism is to do with listing of cases. There is a public perception now that certain cases, like Arnab Goswami's case, was listed very quickly in one day, whereas certain other cases, particularly to do with whether it be Siddiq Kadappan or cases where the government has an interest in delaying the matter, those cases are not listed quickly. Now, and it seems the undertone is that there is, though it's never directly expressed, but the undertone is that there is a certain amount of deliberate conduct that is responsible for this. Now, you are an advocate on record as you file cases in the Supreme Court. So could you tell us a little bit about this listing and whether, in your view, this criticism is justified or not?
Yes. To take it forward, I'll just like to tell you two things about it. Whether you say it Supreme Court or whether you say it Bombay High Court, this thing all depends on the urgency of the matter. If the matter is too urgent, it is a prerogative of the judge. The registrar will put the matter before the judge, the honorable judge, and then he will decide whether he wants this matter to be listed or not. This is the case in Bombay High Court. Now, when we see in Supreme Court, it is a prerogative and discretion of the CJI, like under which bench he wants to put this particular matter before and how urgent it is. So, on that basis, a master slip has been moved. With the master slip, they come to know how urgent the matter is, and accordingly, the matters are listed. The bench is constituted with the consent of the CJI. So, accordingly, we cannot really come and say today that this matter was very, very urgent and my matter was not taken forward, because once you move a master slip, you have to follow up with the registrar. You have to see whether the matter is getting listed or not. So, if it is very urgent, definitely the courts will take it forward.
But are there criteria for this as to when you can move a master slip and how urgency is classified?
See, in this particular COVID-19 time, everything is online. It's e-filing, basically. So once you e-file, you get a diary number. Then the registrar sees the entire master slip, and then the mentioning is done in the court. So after that entire proceedings, the court decides this matter is too urgent, and then they list it out.
So what I'm hearing from you is the fact that there are no criteria of urgency that are listed somewhere, but this is something that you have to do by following up with registrars, and that is why matters get listed. Though that's actually an interesting take, but perhaps this is something, Justice Sri Krishna, I'll come back to you on this. This is something that rightfully causes some degree of consternation. Now, if you know, last week, and I won't beat about the bush, as Pratap Bhanu Mehta in an otherwise well-argued article used the word judicial barbarism. Now, I of course took some issue with that in an article I wrote in the Times of India, saying that, as Salman was saying, that I think we have to be more careful in the words we use. And if we were to look at the facts and we were to look at what has happened during COVID-19, I found that there were 77 cases which were listed the very next day from which they were filed. Some of these cases were listed even with defects. Now these cases were listed with defects. This included not only Arnab Goswami, it included Vinod Dua, it included some public interest litigations, it included Augusta Westland, so it included a whole range of cases. Now, I don't want to come to Mr. Khurshid for this, but there was one common factor which seemed to underlie all this, which is that in most cases there were top-notch lawyers involved. Now, do you think that this is a case where, I mean, this issue of listing and what's been made of it, is it an issue of the court bending over backwards to please governments? Is it a case of certain lawyers, not certain lawyers, but top-notch, well-known lawyers being able to list cases quicker because there are no criteria, as Dhruti has said, but it's a matter of convention and practice? Or is it something else that is structural here? What is it?
Let me start by giving you a counter example. Every one of you must have had experience of going to a hospital, either a public hospital or a private hospital. Now I go to a hospital and say, my child is sick, doctor, why don't you come and look into it? He has a lot of stomach ache, why don't you come and look into him? I think it's very urgent. The doctor will say, hold on, I've got some other person who has got more urgency. Somebody has got a heart failure, somebody has got a kidney failure, I'll attend to it, I'll come to it, nothing is going to happen, take an aspirin and just go to sleep. Now, to my mind, it appears that my child's problem is the most urgent and it should be attended then and there promptly. But to the doctor, he is the one who decides. So similarly, let us put ourselves in the shoes of the Chief Justice. The Chief Justice is the one who accords it. Now, maybe there are no set criteria by which he decides it. Let us assume that he decides it by gut feeling or intuition. Maybe he is right, maybe he is wrong. Everybody can make some kind of a mistake. Now, in doing that, if he is persuaded by a strong lawyer like you that this has the most urgent issue to be decided, well, that may be a little bit of failing on the part of the judge. But do we make a big political issue of that? Do I say that he sold out and therefore he did it? Now you talked of, what is this, Arnab Goswami's case. Arnab Goswami happened to be represented by the lawyer who is well known here and abroad. Now instead of that, if I had been represented by a poor entity like me, the Chief Justice might have said, hey, I don't think it is such a thing. There are other people who are waiting in the queue. Let me take care of this case. Again, look at it. In the court, the same matter can be argued by me, can be argued by a very powerful lawyer. The judge will accept something coming from a very senior lawyer as against me. Why does it happen? Ability to persuade, ability to put it in the proper perspective, that is important. That appeals to the judge. So is it situation of political sellout? I think that's somewhat harsh words to use.
Now tell me something. Now
I've been a Chief Justice. For example, I've been a Chief Justice.
Yes, that's right.
In the Supreme Court, I have lifted matters. Of course, in those days, nobody even talked of the judge being politically aligned. At least nobody called it to me, at least. Sorry, you were saying.
Yeah, no, but I was saying that is there, since Mr. Khurshid is here, I was wondering, Mr. Khurshid, we were just discussing this question of listing, and we were saying as to whether this is really a question about the court selling out to governments, or is it a question of just lawyers, as Justice Sri Krishna said, being able to persuade judges that their matter is urgent. I was wondering, one, what your take is on this issue, and two, that do you think that perhaps something completely different is going on here, which is that this is an issue on which questions were not asked earlier, because there was a greater degree of trust that exists not only in the system but in society generally, and perhaps those trust relations are breaking down. I'd like to hear your views on this.
Well, shall I give away family secrets? Because I had the opportunity for a few months to be the law minister. And I had, obviously, before that and after that, I've had access to and friendship with a lot of judges, much as I have tried in my life to keep a little distance. There are some people who exaggerate their friendships or work on their friendships. Maybe sometimes even flaunt their friendships. But for me, the respect for a judge is largely due to keeping a distance. I'm very happy to socialize with them once they've retired, and they are wonderful people, but to keep at some distance while they are judges. But when you become a law minister, you can't be saying I stay at a distance from judges. Because the expectation of a law minister is largely to see the important work of government, to see it through, and see it through means including through the judiciary, which doesn't mean that you go and tell a judge, I want you to do this, I want you to do this, but there is a legitimate thing that, and you can only impose restrictions on yourself as to how much you would say and how often you would say it, but that you would share your deepest concern about what is happening and what the government wants to achieve. It's not about putting somebody in prison, right? And it's not about having someone released from prison. It's about the broad perspectives of governance, where the judiciary and the legislature or the government are not necessarily at loggerheads. They may well not be on the same side, but they are, in terms of committed to values, if we are all committed to values of the Constitution, and the implementation of those values as a special concern for a government has to be communicated to judges, the Chief Justice, and to people. One way to do it is to use the law officers who have a day-to-day kind of connect with judges or the Chief Justice to say, well, this is our concern. What we want is, we want a constitutional bench to be set up quickly, because we want to test this before a constitutional bench. You're not telling them, please decide in this manner, but what you're putting out is a priority of government, which is at much their priority and ought to be their priority as it is yours. But the critical buffer where you don't cross the Lakshman Rekha and say, this is what I want you to do, that is something you can only restrict yourself upon. This happens also. This happens also when the Chief Justice wants to persuade you about a particular candidate for judgeship who he thinks is outstanding, but where there may well be constraints, restrictions, impediments along the path. There is nothing wrong in his picking up the phone to say to the law minister, I really do think this is an outstanding candidate, but there are issues, there are problems. Please see what you can do about having him pushed through. Now, a relationship of mutual respect, which you will not exploit by telling the world, what do you want me to say to the judge? And the judge saying, I can have this government run circles, etc., around me. That is the expectation from both ends, from both sides. If it's possible to do it, you've got a wonderful working relationship. If it's not possible, then you ought to just stay away from each other. But it is something that will break down when there are deep divisions in society. It'll break down if some people just don't understand the other point of view, because the judges may also have an impediment about not understanding the other point of view. What happens then? This is something that we need to reflect about. And there are no easy answers. There are no easy answers and no systems that you could put in place except your own conscience.
Well, that's great. I think there's a lot of food for thought there. But you were law minister, if I'm not mistaken, about a decade back or so. And now you're, of course, fully in practice as a senior advocate. As in, do you see things having changed in these 10 years?
Well, things may have changed to the extent that I think that there isn't the same expanse of willingness to respect. We can't be in a transactional relationship. It can't be you do this for us and I will do this for you. Chief Justices have always asked chief ministers, I need another building. I can't run my court without another building. Please give the money. And there are chief ministers who say won't do it, and there are chief ministers who say, Chief, just ask and you will have it because it's your right. Nobody is doing anybody a favor. These are all people who have constitutional entitlements. And I don't think that one should read motives there, etc. Some people just want to have good relations, to be friendly with judges. That's a good thing. That's a good thing. As long as we remember that we are on the same side, irrespective of what finally we will take as our decision, I think that is very, very critical for the judiciary and for the government.
Yeah, and I think that's actually a very good point that you spoke about buildings, because the reality of our courts are that we did a national survey on judicial infrastructure and we found that 100 district court complexes, and these are not municipal courts, these are district court complexes, don't have toilets for women. They just don't exist. And people have to go out into the fields to relieve themselves. Now, that's the reality of the judiciary we are in, and that's where governments and courts need to work together as in to make this happen. But we are in a different kind of debate now, and so Dhruti, I'll come to you on this point, which is again as in the public eye. And if anybody has any further questions on this, please do feel free to type it in the chat box, and we'll try and take as many questions as possible from in about 10 minutes or so. So Dhruti, I'll come to you. There's been another question that's been raised and which has been doing the rounds in the course of the last couple of weeks, which is about Article 32 and Article 226. Now, I know a lot of people listening in are not lawyers. Article 32 is the original jurisdiction of the Supreme Court if fundamental rights have been violated, and Article 226 is the original jurisdiction of the High Courts, including the Bombay High Court, where Dhruti is, in case any right, including a fundamental right, has been violated. Now, this is a choice that is given to litigants as to where they want to go in certain matters. And there has been a lot of talk recently that the court is trying to discourage Article 32 petitions, given the fact that they want people to exercise their remedies in the High Court as well. You're a lawyer practicing in both courts. What is your practical experience of Article 32 vis-a-vis Article 2?
Actually, Arghya, can I interrupt you for a moment?
Yes, please.
This is something that we had been doing when I was also on the bench.
That's right.
I'm talking of 15 years ago. The pressure on the Supreme Court is so much that they don't have time to breathe. So if there was something that could be conveniently done by a High Court sitting in the capital of the state, we always said, please withdraw and go and file it under 226. You will probably get better results there and faster results. I mean, this is not intended. I don't think the Chief Justice of India intended to be a policy matter that will not interfere in 32. He was saying, everybody, you're right. Article 32 is a fundamental right in itself. Ambedkar has said so, everybody has said so. But if you take it in the literal sense, you will not be able to run the Supreme Court unless you have another 50 judges.
That's right.
So there are matters which are purely, location bound. If something happens in Bombay, the judge in Bombay knows exactly what is good, what is bad, what is indifferent. So instead of asking the judge in Delhi to make a second guess, you tell him go and move it under 226. Probably you will have a better remedy there.
That's right. So actually, Justice Srikrishna, you're right. You're absolutely on the money, because this criticism actually left me quite befuddled. And if it came from someone outside the legal profession, I would understand it. But as in an Indian Express column, as in Mr. Navroz Sirvai also has written this. And I was frankly surprised that maybe I'm getting something wrong, because it was not just with you, but going back to Justice Hidayatullah, as it's always been a principle that you have to exhaust alternate and efficacious remedies in the High Court before you come to the Supreme Court. It doesn't mean the Supreme Court will not take it, but the Supreme Court may not take it.
Look at the common sense thing. I am sitting in Mumbai. I have a problem. Why should I be interested in going to Delhi all the way, engage a lawyer there and spend money there and wait till my matter is listed and then do it? Why can't I walk into the Bombay High Court, ask Dhruti to go file a petition and get it done?
That's right.
It's a simple remedy. There is something called Dravid Pranayama. You can eat like this or you can eat like this. That's all that the Supreme Court said, and that is all that the CJI meant actually.
That's right. But Dhruti, what is your advice to your clients?
See, whenever my clients come to me, they're like, this is the issue. I want to file a writ petition. I would tell them, look, Bombay is more cheaper. It's more expensive than actually going to Delhi. Not only that, we'll get faster remedial situation here because the judges in Bombay are well versed with the laws. As Justice Sri Krishna just said, they know what exactly is happening in Bombay. So better remedy would be here, and let's expedite the matter here as early as possible so you get the remedy quickly here. And if we fail here, let us go to Supreme Court as an SLP. Directly going to Supreme Court is not my advice always. Because I always feel going to the Supreme Court is just like a last remedy if a person wants to do. Let's use the first remedy available, that's Bombay High Court. If we have it here or Delhi High Court, whichever High Court you have available. Because what happens to citizens, they feel if you go to Supreme Court, then what more? The expenses go higher and higher for them. And the judges are anyways burdened here and as well as in Supreme Court. So why not utilize the skills here where we can, because it's more faster for them to understand what is procedurally applicable in Bombay city, if I'm taking in the Bombay matter. So I always tell my clients, Supreme Court will go as a next step if we need to go. Let us first do it here. 32 directly, if you want to evoke, it doesn't really make sense in the first step. This is what I always tell them.
Yeah, Arghya, another thing is, Article 32 is intended as an extraordinary remedy. Look at what happens. Now, every labor dispute, every order that you want to challenge, one of the grounds is that it is arbitrary hit by Article 14. So technically, it is a fundamental right that you want to enforce. If you go and sit in the Delhi and ask the Supreme Court to decide it, every service matter will have to directly go there. Every matter which deals with army service will have to go there. Every labor matter will have to go there. Any arbitrary decision taken by an executive is directly hit by Article 14, then you have to go there. So that is why we used to persuade them and say, hey, this is something that can be done by the High Court. Why don't you go back to the High Court? And I don't think we should read too much into what the learned Chief Justice's observations were. They were made probably in a general spirit and nothing extraordinary, exactly what was being said. I have said so in my court while sitting 15 years back as a judge.
That's right. So I think we'll come to the larger issue that Mr. Khurshid was raising, because that seems to be the key to some of these criticisms, which is that perhaps we are in a phase where we don't talk to each other, or where we feel that any kind of disagreement is disrespect. Now, Mr. Khurshid, this obviously, as this atmosphere that you're talking about is not just limited in other spheres, but seems to be creeping into the judiciary as well, particularly when senior members of the bar, as in instead of having a polite conversation at the next dinner party, that they meet the judges, as used to happen, as a long tradition of this has happened. Instead, are writing publicly and expressing their dissatisfaction in public. Now, how do you see a way forward from this, particularly in the judiciary? That how do you see that we go get ahead? What are the reforms that the judiciary needs to undertake to win back this trust and create or recreate this atmosphere where we can talk to each other about differences without necessarily being as in having any animus for each other?
Well, truthfully, if I had all the answers, I would be the most sought after person in the country. But not having all the answers, I can only access Vidhi and use you as a possible platform.
No, that's a bit of a cop out.
I think it's a lot to do with judges individually. You can see it in every high court. You can see it in the Supreme Court. There is a judge. There is a judge who doesn't invite the angst that some other judge invites. There is a manner and method of being able to communicate, and they do it all the time. Sending someone for someone in chambers, asking them to come over for a cup of tea, and that doesn't become an issue. That, oh, why did this judge call so and so for a cup of tea? But that kind of self-assurance and that kind of confidence in the bar is something that must be revived. It can be done. I don't think it's difficult, particularly since many of the judges come from the bar. There are people that you've rubbed shoulders with in the bar rooms and in the canteen, that you have opposed in court, or you have been on the same side. There's no reason why suddenly a judge should feel that I now need to keep a vast difference. A little bit of aloofness is good. It's useful, and I think should be encouraged. But that shouldn't become a huge yawning gap between the judge and the bar. And the bar must know that once somebody becomes the judge, they have certain responsibilities and constraints. And therefore, you shouldn't be thinking that, this person has changed so much. He used to be a lovely member of the bar, but look at him now. So I think there are enough models available for ability to communicate. But that's one part. The other thing that's been troubling you is about this, and Justice Sri Krishna talked about Article 32 and so on. The problem is a problem that the judges don't create. It's a problem that's imposed on them, because we function in the Supreme Court in small benches of 2 and 3. One bench that one knows has a strong freedom of speech attitude. Another one a little more conservative. So when the bench that is very strong freedom of speech attitude bench gets a case, you will get the outcome. It doesn't matter who it is, whether it's a right winger or a left winger or a crazy person, you will get the same outcome. And if you are in front of a conservative judge, then the outcome will be different. And coincidentally, it could be that the outcome being different and the petitioner or a person being different becomes the contrast that outsiders don't understand. Why should X have freedom to scream, and why should Y be told, shut up, you can't scream, etc.? But that's the problem of structure. It's not a problem. So if there was one court giving answer to everybody, then everybody would have the same answer. But there are separate courts giving answers. Now, this is something that the Chief Justice of the time has to handle, to ensure that there's likelihood of a collegiate conduct in the judicial pronouncements, in the sense that there has to be a team. The judges must be able to see that they are in a team working towards a particular articulation of the law. But that's not easy, because the structures are such that you can't call them all together over lunch and say, well, we are all going to do this now. No, none of you. So each judge will say, well, I'm a free bird. I'm just as good as you. So why should I agree to you, and so on. Now, of course, the way the Chief Justice finds a path out of this is by constituting larger benches from time to time. And that's how they try to get the law on track. But it can be a problem. And I am glad that I'm not Chief Justice.
Justice Sri Krishna?
I'm glad that I'm no longer a judge.
but actually on this issue, as in we had done some research and we found that because there are lots of suggestions, break up the court and so on. But we do think that there should be, given the fact that the Supreme Court is now 34 judges, this is just too large for one court to function coherently. There will be these differences and people will think, that there are false causations. And I think that we should always have a permanent constitution division of 7 judges who hear constitution bench matters on a permanent basis. And we should have the rest of the judges broken up in groups of 3 and a separate admissions division. But I think that there must be a separate constitution division which operates permanently, so that at least on significant questions of law, at least on those questions, there is clarity. And another issue is death penalty cases, which is where, so just to complete, this is death penalty cases where we see that these disagreements between judges could have consequences that are fatal to some. You go before a judge who's abolitionist and you'll get your freedom, and if you go before a judge who's pro the death penalty, as you could lose your life. This is too big a price to pay. Yes, sir.
I just wanted to interrupt and say that I remember in the good old days when I was at the bar, there always used to be a minimum number of 3 judges in any bench in the Supreme Court. And a 3-judge bench, whatever their pronouncement was, if it was, they normally followed what a coordinate bench said, and unless they have a difficulty in which it went to a constitutional bench of 5 judges or more.
Right.
So we did not have this problem. Now every 2 judges, technically the 2 judges are speaking for the Supreme Court. So that is the precedent that would have to be followed. But then the way things are done in the Supreme Court has invited a lot of criticism.
That's right. So we are open for questions. We've already got a few. We've got about 15 minutes or so to take some questions. So I'm going to start with this one from Alok. And Justice Sri Krishna, to you. Given the evidence of judges becoming pro-government in their judgments towards the end of their tenures, is it time to heed Professor K.T. Shah's suggestion and stop judges from holding any post-retirement posting whatsoever once they retire, while raising the retirement age to 70?
As a matter of fact, one of the suggestions that was made, I remember I was still in the Supreme Court. We had a long discussion with the Law Minister or the Finance Minister, which were both of them probably, saying that as far as the judges of the Supreme Court are concerned, don't have a retirement age. Treat them as on duty toward like the federal court judges in the US. Let them draw pension at the rate of the last drawn salary. If the government or the president wants them to do something without any further remuneration, he will have to do it. He's like the army has a reserve of officers after they retire. So when he's called to work, when there is a war, he's called. But that was not accepted on the facile ground, that if you give this facility to judges, all the IAS officers will demand it and it is impossible to fulfill it. Well, that was the answer that was given, which did not make any sense to me then, doesn't make any more sense to me even now.
That's right. We'll take a couple of sort of slightly more difficult questions, but I think these are genuine feelings, so I think it would be useful to try and answer this. Nasir asks, why has the Supreme Court been skirting around the constitutionality of abrogation of 370? Several changes to land laws and demographic laws have already followed the abrogation, and the executive then has not been kept in mind that the matter is sub judice. Why this difference in such important cases? And I'll link that to another question that has been asked in relation to Stan Swamy. In the case of Stan Swamy, the special court seems to have rejected the petition based on the technicality that the NIA did not confiscate his belongings, and they have asked for the jail authority to respond on a technicality and adjourned the matter till the 4th of December. This is also a personal liberty case. Why does common sense not prevail here?
All that he wanted was a sipper or a straw or something, right?
That's right.
That's why I said your urge should be to do justice, albeit within the provisions of the law. Now, if you fail in that, you have failed your oath of office. Don't forget that. Therefore, the way I look at it, this straight path is indicated by your oath of office. How much you deflect from it, how much you deviate from this, shows the caliber of the judge. That's all.
That's right.
Then the nearer you are to the oath of office, the better judge you are.
So actually the Stan Swamy case, and Mr. Khurshid, there's another question from Lalit, which I'll take to you, which I think is an interesting one, which is, do laws like the UAPA with weaker procedural safeguards and greater technicalities and relaxation of this presumption of innocence make a difference to how courts treat decisions on questions of bail? Does it make it easier also for government to target political rivals?
Well, I have to admit that there is a very disquieting element, but the statement would then be treated as a political statement. This is not the first time and the first government that has had legislation that one would, if you are a civil liberties person, you would be uncomfortable with. We've been in government and we've had similar legislations. Courts have struck them down periodically, etc. We've reacted to, sometimes in TADA, for instance, reacted to public opinion and tried to dilute it and so on. The Supreme Court has done some wonderful things about securing the individual so that these laws are not misused. But the sad thing is that the same thing does not filter down to the trial courts, particularly the magistrates. Now, you know, when the anticipatory bail was reintroduced in UP, the magistrates and session judges didn't have any idea as to what was happening, and the Supreme Court had to send colleagues, Supreme Court judges, and to go down to hold seminars there, because each judge said that for 20, 30 years, we have not known what anticipatory bail is. But you know, the jurisprudence on anticipatory bail is very clear from the Supreme Court. Now, this is something that is unforgivable. This is something that should not be tolerated. That we have some outstanding jurisprudential propositions from the Supreme Court, and when you go to the magistrate, it gets rejected, the sessions rejects it, then the High Court 50-50, there's a rejection, and then finally you could end up in the Supreme Court and get endorsed by the Supreme Court. This is a very unsatisfactory situation, and therefore I have to say that we just as a nation have to learn, and the Supreme Court has to push us towards putting in very strong safeguards, because these laws are often misused.
I have a classic case. I was sitting and hearing preventive detention matters and criminal matters in the Bombay Court on a division bench. And there was a case of a person, the basic accusation was one of rape. And they added TADA to be in greater measure, so the man would not get a bail. He would not. So I said, since when has rape become a TADA offense?
That's right. And that is the unfortunate reality, and I think it as the number of laws in the arsenal.
That's why.
Every state has this. Even our Maharashtra has that Makoka or whatever.
Makoka, yeah, that's right.
UP has one. Kerala has one. Karnataka has one. So the whole idea is, I mean, this is true all over the world. Every executive wants to have this kind of authority, which it wants to use unchallenged by a judicial authority, untrammeled by a judicial authority. And that is an unfortunate thing. Therefore, we have to fight against that.
Yeah, and
Arghya, that's why the rape of the lock was written.
That's right. Absolutely. We'll move on to a couple of other questions. Dhruti, this one's to you. Prakhar asks, if the ability to get heard depends on how influential the lawyer is, the faith of majority of Indians of the judiciary would naturally decline. How can we change this scenario and make the system more inclusive?
We do hear many times that if you take X person before this bench, the matter will be listed or will be heard. We honestly do hear this, but this is not the true fact always, to be honest. So to change it, the judge has to be taking a mindset in such a way that there's no discrimination done. Say a junior lawyer goes before him, even he can hear the matter. Say a senior lawyer goes, he should hear the matter. So there should be an equal treatment to all, which should be done. And how do we improve it is it's just, we don't know how we can really work it out, because there's no such solution for it. It's just the mindset of the people who would do it. That would change. Give equal respect to all, and the matters which need to be listed earlier will be getting listed. And if the matters are not really worth the urgency, they will not be getting listed. Whoever goes before the judge. It should not be a matter of who's going before the judge.
That's right. That's right. Another question, as in this one, Justice Sri Krishna, Professor Johar asks, are we not realistically seeing the philosophy of the realist school of law in action in courts, including the higher judiciary? Is it just not legal realism that you're seeing?
What is the realistic school of philosophy? Law is what the judge says.
Law is what the judge eats for breakfast, and so the judgment is according to that.
Since I'm not much of an eater, I modified it slightly and said, law is what the judge says. Now, in a way, it says that is true. Now, I don't see anything wrong with it. See, the point is, your philosophy is not what the judge is going to implement. The judge is doing something, and from which you are drawing a philosophy. Somebody will say this is the realistic school, how it sees the judicial process. Somebody will say some other strict construction process. Somebody will say liberal construction process. Now, judge reacts to the situation by his own conscience, the judicial conscience. The driver of all judges is the judicial conscience and the fact situation. Now, from that, you can come out with whatever philosophy you want. I didn't sit as a judge and thinking of what was the realist school of, although I did remember having studied sometime in the law school about the doctrine of realists and all that. That didn't matter much to me. You look at the facts of the case, you have an intuitive feeling that there is something wrong here. Try to set it right, but within the parameters of the law. That's the end of the debate, nothing more.
Well, Mr. Khurshid is a Dworkinian, so he may not agree with this. But
we need another day. We need another day, another discussion on this.
We need another day, another discussion. There's one more question, and then we'll end with this. So there are a couple of questions on solutions and to senior advocates, and this is so. I'm going to ask you this, Mr. Khurshid. If the courts cannot be, the courts of course cannot be expected to engage with criticism widely circulated on social media. But what about legal scholarship, which has empirically shown that the presence of senior advocates is statistically significant in hearings, in cases? And related to that, there is a question that are there any inputs that you have on making the case listing process more objective in the Supreme Court?
Can I answer the first half of the question?
Certainly, and then we'll have the last word for Mr. Khurshid.
Now, being a judge, I'm short of time. I have hundreds of matter. If somebody comes and talks irrelevantly for half an hour, he's wasting my time. I tell him, you're wasting my time. But if let's say Salman or somebody equal or better than Salman comes to me and in 2 seconds tell me what the case is, whom do you think I should encourage? Yeah. Yes, I know as a judge I will encourage. In fact, I'm not talking of what my personal practice. My personal practice was to encourage juniors and make seniors run away from me. That's a different matter. But then what is the normal human being's reaction? Would you like, if you're traveling on a bus and the conductor keeps on talking nonsense to you, do you have the time to listen to him? Or vice versa. If you are a conductor and the passenger talks irrelevantly to you, you have time to listen to him.
Yeah, that's right.
In the court also. That is why senior lawyers are paid so much, because they know exactly what the point is. In the shortest time, they put it across in the most effective manner. The judge appreciates it. What is wrong in that?
I mean, with the greatest respect at my command, as in some senior lawyers may not, and some junior lawyers may do better as well.
No, if you want talking of exceptions, I was an exception. Nobody ever said all the juniors in the world, in the 3 courts that I have presided over, swear by it that I gave them enough opportunity, and I would tell the senior center, you go finish your coffee and come back, I'll listen to this.
That's right. That's right.
But I have told juniors like Dhruti who appeared in my court and said, if you know the fact, tell me the fact, I'll supply the law. If you know the law, tell me the law, I'll supply the fact. If you know, just stand up there, I'll read it and tell you what you're
That is
we do have, just to add on, we do have such judges here in Bombay High Court also that I've experienced. They're
good judges. Whether I was not, I don't claim to be a good judge, but such good judges are good.
We sometimes say that judge shouldn't be judges, juries, and executioners, but Justice Sri Krishna is judge, lawyer, and litigant put together at the same time.
I see that the person is going to suffer. In fact, I remember one of the judges in Bombay, a very senior man, very vocal man, who used to say, I am holding in favor of your client in spite of you.
That's
So we have a new school of jurisprudence called the 3-in-1 school of jurisprudence.
3-in-1 school.
Ultimately, lawyer is not sworn to, he has no oath of office. I have the oath of office.
That's
which
right.
is not bothering me all the time. I'm sitting on the judicial chair.
But that's right. But I think we're clear that we need more judges like you. But in terms of solutions, Mr. Khurshid, last word to all of you. One, lot of questions are about solutions. How can we make the listing process more objective? How can we restore this crisis of confidence? Mr. Khurshid.
Well, I think the listing process is a lot better now than it used to be. It's a lot better, but the exception has been left there a little opaque, so that and I think that it stands to reason that you can't tie your hands down to a mechanical computer-driven listing, because you may well require to intervene somewhere, because there is something of great importance, national importance, etc. And the chief can't be saying, look, my hands are tied, the computer will not let me enter at all. So it has to be, you have to wait for the computer. So there will have to be exceptions. I think you've got to trust the Chief Justice of the day. But for the rest, I think the computer system can be an adequate answer. I see no reason. Use artificial intelligence, and I think that would be fine.
So computer generated listing, and in edge cases, which we can specify the criteria for, leave the discretion with the Chief Justice. That's a good thought to end with. Dhruti, quick suggestion, any reform suggestion from you?
I would rather say what's happening today. I would go from the Bombay High Court point of view first. It's a very nice procedure. Urgent matters, we move precipice, and the associate puts it before the judge. If he thinks it's urgent, it's listed now. Particularly in the COVID-19 time, we learned so much more of technology being in that immediately we get the lodging number, we immediately get the matter listed in 24 hours. So I think things are changing now. Imagine those matters which you want to get it listed would never get listed for months. What would you do to get your relief urgently? So I think this process is good, and computerized system should also be now judged out in a proper software system where we know which matters are backdated of 2018, 2019, they should be taken up, or 2010 matters should come up earlier. So some management in the softwares would really be useful. That's my solution intake to it.
Justice Srikrishna, anything in the Narada Smriti for judicial reform?
I told you,
anything else? Anything else for the last word for everyone to take away?
This. Ultimately, I will also end on this listing business. Look, listing can be computerized, but computer cannot by itself judge the severity of a situation. Computer can say, hey, this is Article 21 matter, this is Article 14 matter. Therefore, I will take 21 first and 14. But among the 21 matters, which needs greater attention, how are you going to determine? Computer can never determine. Yes, computer can determine it. If computer can play chess and beat Kasperovsky, computer can determine that also. But that will come another 15, 20 years later, after the computer has been sufficiently fed with information and data. As of today, the computerization will not help. You have to trust somebody somewhere along the line, and that is the Chief Justice. Now, if you don't trust him, you replace the Chief Justice or wait for the new Chief Justice if you can't replace him. What else can I say?
That's right. Yeah, I think that will be the day, maybe with the artificial intelligence that we have seen in the judiciary.
Why do you need Chief Justice? You don't need judges at all then. You can hear, then you can, like a vending machine, you can put your facts in, press a button, drop some coins, sufficiently large number of coins, then automatically the judgment will come out.
Yeah, that day may not be far away. I had a chance.
I'm not sure if it comes in my lifetime. Probably you will see it.
That's right. So we hope to carry on some of these themes in a couple of other forums. This is the series of public conversations. Yes. So next week we have the Vidhi annual public lecture, which is also the first Samvidhan lecture. It will be delivered by Justice Dama Sheshadri Naidu, a judge of the Bombay High Court. In previous years, we've had Justice Chalameshwar, Justice Rumapal, and Justice Gautam Patel who have delivered this lecture. We are delighted to hear from Justice Naidu, and you'll hear some of these thoughts on constitutional culture in public life on the 3rd of December in the evening. This is part of the Samvidhan Annual Summit, where we'll also be discussing issues on COVID-19 and federalism on the 4th of December. That will be with Professor Louise Tillin of King's College. In the evening, we have a very special session on gauging the health of India's democracy with Suhas Palshikar, Shruti Kapila, and Naveen Chawla, a former Chief Election Commissioner. We'll be discussing issues around electoral democracy. And on the same day, we also have a session on presumption of innocence in the Constitution with Neha Singhal, Mrinal Satish, and Kunal Abbas. So there's several forums where we want to continue these series of public conversations so that people get to know about this. There's also in your chat box with his podcast called Justify, where we are doing a series of discussions. This time I have spoken with Justice Chelameshwar and Tripur Daman Singh on free speech in India. I think that would be of great interest to everybody. So the short answer is this is not the end. This is only the beginning. And as Mr. Khurshid said, we must continue to have these conversations so that we know firsthand what is going on in the judiciary. And thank you very much, Justice Sri Krishna, for giving us such a detailed firsthand account of what your life in the judiciary has been. This is something that we can all aspire to. Thank you, Dhruti, for giving your practical perspectives of what your experience in court has been like. And thank you, Mr. Khurshid, for sharing your thoughts frankly and candidly. I really appreciate all of it. Thank you very much for everyone for joining us today. And we have a series of conversations coming up. So look forward to seeing you then. Thank you once again. Good night.
Good night.
Right.